for landlords and property professionals. Our speaker today is Mr. Leong Chi Wang, a highly respected speaker and advocate and solicitor of the High Court of Malaya. And if you have any questions during the session, feel free to drop them in the Zoom chat, which will be addressed during the Q&A segment at the end of the session. Without further ado, please join me in welcoming Mr. Chi. Welcome, sir.
Hi, thanks, Nafa. Thanks again, Excel Academy, for having me today to share on an interesting topic, the Tenancy Act. I'm sure most of you may have known that recently there's been a lot of initiative on passing the Residential Tenancy Act, which is also something that we will discuss today. I have also prepared some slides, if I may. Now, if I could trouble the host to enable screen sharing. Today's topic is on tenancy, which I think most of us will be familiar. At some point in time, I'm sure some of us would have rented a place. I personally has been renting even when I was studying abroad. And for those who own property, you may have, rented out certain places as a landlord. And of course, as being a landlord or tenant, you may want to know what are your rights, what are your obligations, the importance of having a properly documented tenancy agreement, what are the common problems. So these are some of the some of the topics which we will aim to cover today. So and to also add, some of you may be surprised to know that a lot of tenancy dispute actually end up in court. Me personally, I've actually done so many. A few recent one is on tenancy dispute where we act for the landlord. The typical dispute where the landlord do not want to return the security deposit at the same because of the fact that the tenant have not restored the units to its original position, because usually typically in a tenancy dispute, in a tenancy relationship, once you've rented the place, before you return the unit to the landlord, there is an obligation to restore the premise to how it was. And in that particular dispute that I was involved in, the premise was rented to a tire shop, one of the more renowned tire shop. And therefore, when you have a tire shop, you have workshop, and when you have workshop, of course, the leveling would be very different, because when you service car, there's certain elements of digging and excavation that needs to be done. So when the tenancy have expired, when the tenant need to return the unit to the landlord, of course, then issue arose, right, on whether the tenant have done a good job to restore the premise. And of course, then the tenant sued the landlord for the return of the security deposit. And a lot of issue arose, including whether there's a right to withhold the security deposit, whether there's a right to forfeit the security deposit. So these are some of the topics that we will cover today, and we will also try to cover the Residential Tenancy Act as well, on the proposed, what does the proposed act intends to introduce and address. So if I may just share screen. So I think Naufa. Oh, yeah.
Yes, sir. It should be enabled now.
Yeah. All right. Okay. Yes. So yeah, these are some of the topics that I'll aim to cover today. Number one, of course, just give everyone a brief introduction of what tenancy is all about, the difference between lease and tenancy, obligation as a landlord, obligation as a tenant, and some of the important areas that need to be covered in your tenancy agreement. And then, of course, we'll move on to some of the common problems, right? What are the common breaches or some of the common issue that landlord face? Non-payment of rent, and then, of course, the common problem that tenant faces as well, right? Where the landlord is not cooperative. So what are your rights? What can you do? What is the Malaysian position? And then, of course, lastly, in part 3, we'll cover the famous Residential Tenancy Act, which for the time being has not been enacted. It is still in the midst of consultation, what has happened is the PKT have actually proposed a bill, right, to regulate tenancy, to include certain regulation to regulate residential tenancy. So we will discuss what is the purpose, what are the key areas that the Act is aiming to regulate, what is its limitation or challenges that we face, right? So the first one, of course, is some just preliminary introduction so that everyone knows what tenancy is all about. First of all, of course, the importance of knowing the difference between tenancy and lease. Of course, many of us may not know the actual differences because sometimes these differences is just essentially the duration, right? When you have 3 years or lesser, it is actually deemed as a tenancy. Whereas if you have 3 years and above, more than 3 years, sorry, it is deemed as a lease. Why the distinction is because there's the need to register with the land office, which is why it's very common that oftentimes they're not your rental. If you look back at your tenancy agreement, you always be a 2+2, 3+3. It will never be beyond 3 years, right? Because the moment that it is more than 3 years, there's a requirement under the National Land Code for it to be registered. And in cases of also being strict, if you do not register your lease, right, as a tenant, even is the key distinction, number of years, and the other key distinction is also as far as for tenancy is concerned, there is actually a option for tenancy to be created by word of mouth as well. Doesn't need to be in writing, right? Or even by conduct. So you can create a tenancy. So that's just a minute detail for everyone's knowledge. But I think more importantly, for those who attend the talk today, you will want to know what are your obligations, right? You have rented a place or you are a landlord, you're renting out your place to a tenant. So you want to know, okay, what am I supposed to do? Now, what I've highlighted in the slides is just some examples. It may not be applicable to all tenancy because at the end of the day, it will still depend on your tenancy agreement, right? Your rights, your obligation, whatever avenue you have in the event of any issue, it will all depend on your terms of your tenancy agreement, which is why it's very, 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 very important to make sure that your tenancy agreement is properly drafted, right? So in any event, later I'll also cover the area of what needs to be covered in a tenancy agreement. But for now, I'm highlighting some of the common obligation, right? As what you can see, some of the common obligations, number one, of course, as a landlord, you need to pay all the necessary charges, right? What are these charges, you may ask? It may be, for example, your quit rent, assessment, and if the landlord owns a condominium and you're renting the condominium to the tenant, the agreement may stipulate that it is for the landlord to pay the maintenance charges and the service, and the sinking fund, and all this in the condominium, right? Again, it all subject to your agreement. Sometimes these charges will be borne by the tenant instead. But sometimes if it's in the agreement, there's certain charges landlord have to pay, you have to pay these charges. And sometimes landlord may also cover electricity as well. So as landlord, you need to make sure that you pay for those electricity. And then the second more common obligation, of course, is the need to maintain insurance for your unit. It's very common, especially as landlord, you need to maintain the fire insurance, right? There's a need to maintain fire insurance. And then thirdly, of course, the need to maintain some of the property's infrastructure as well. What do I mean by that? Like, for example, sometimes you may have certain equipment or certain inventory in the unit which actually spoiled, right? For example, the aircon is not working or the piping, there's some issue. So some tenancy agreement actually put the obligation on the part of the landlord to ensure that these are all repaired, right? So some of the clauses in the tenancy agreement will stipulate obligation on the part of the landlord. And of course, the most important one, right? The most important obligation of all is as a landlord, there's an obligation for you to ensure that the tenant can have a quiet enjoyment of the property, right? As landlord, you may think that this is my unit, I can come as and when I like, or I can come and use the facility as and when I like. That's not the case, right? When you have agreed to rent it out, of course, the understanding is you will not come into the house as and when you like, right? There's no such thing. There is obligation as a landlord not to interfere with the tenant ability to actually enjoy the unit in which they have rented. So that's for the landlord's obligation. And now we're going to some examples of the tenant's obligation, right? As far as tenant is concerned, again, the caveat is there, which is that these are only some of the samples of the obligation. Again, ultimately, it still depend on your actual agreement. Another common one is, of course, is given the obligation by tenant to pay relevant deposit. And this deposit typically is 2 months security deposit and 1 month utility deposit. And the purpose is to provide certain security to the landlord, right? In the event that there's something in the unit that spoiled, right? And the landlord need to fix it. Or for example, if the tenant refuse to pay rental, at least the landlord have some sort of a security, right? And then the second obligation, of course, is to pay rent on the agreed date, right? There will be this typically is to pay on the 1st to the 7th of the month. And of course, if you don't pay, then there's certain interest, or in some instances, landlord may even terminate the tenancy as well. And then, of course, you also have the duty to notify the landlord of any necessary repair, because earlier just now I mentioned as landlord, maybe certain obligations on the landlord to fix the aircon or fix the pipe or whatever. But of course, the landlord is not in the unit, so the landlord wouldn't know what requires to be fixed. So as a tenant, there is obligation for you to notify, right? And to notify as early as possible so that the problem can be fixed as early as possible, as opposed to letting it deteriorate and getting worse and worse. Then, of course, you have also the duty to keep the property clean and safe that is given. Since you're staying there, it only makes sense as a tenant to ensure that the unit is safe and also clean. And of course, there may be, like I mentioned, certain obligation for tenant to pay utility bills, right? This one is a bit more flexible because sometimes the obligation may be with the landlord, sometimes the obligation may be with the tenant. So the obligation is with the tenant to pay electricity bill, internet bill, water bill, and whatever not. Of course, then the tenant has to make sure that they comply and pay these bills. And the more controversial one, of course, is the permission for any subtenant, right? I think it's a very common practice. I understand some tenant, what they do is they rent the entire unit, but perhaps that unit will have 3 rooms or 4 rooms, and then they sublet it to different roommates or housemates. Sometimes you may even have better return, right? As the main tenant, you rent the unit, but the rental you collect from renting out different rooms may even cover your entire rent as well. It may sound tempting, but you have to be careful because some tenancy agreement actually prohibits this, or at the very least will require the tenant to obtain a consent from the landlord. Because sometimes being a landlord, they want to know who this unit is being rented out to, right? They want to have control. They don't want a situation where they rent it to you and then you rent it to someone that the landlord do not know. So they want to have some sort of control, which is why some tenancy agreement will have the obligation saying that if you want to sublet it to any subtenant, you need to first seek the consent of the landlord. So that's very important. You need to make sure that if you want to sublet it, there's no such prohibition or there's no such requirement for consent. Now, of course, then for the commercial purpose of tenancy agreement, sometimes the agreement will stipulate that you're renting this for a particular purpose, right? Your obligation as a tenant is you need to ensure that you don't go beyond the purpose or don't even go and use it for an illegal purpose, right? For example, you're renting it and your tenancy agreement may stipulate that this is for you to run a restaurant, right? So if it says it's for a restaurant, you cannot then change it to a cyber cafe or change it to a tire workshop. This will then you'll then be in danger of breaching the tenancy agreement. So again, as a landlord, they also want to know what you are using it for, right? Some maybe landlord will have religious purposes, right? They do not want it to be used for something that is, not within their religious belief. So the agreement will say that, okay, if you want to run this restaurant, it's okay, then you don't change it for something else. So that is an obligation of tenant. And then, of course, for residential units, there is also obligation as a tenant to make sure you comply with the condominium rules and regulation. Like for example, the common rules for condominium is there's no pets around, and you don't violate the parking, and how you use the common facilities. Those are very important, and usually will be stipulated in your tenancy agreement. Now, in first glance of these two slides that I've just taken one may wonder to say, hey, how come it seems like the tenant appears to have more obligation, right? Even the samples that I've highlighted, since the tenants have more obligation than the landlord. Now, to that I say, number one, yes, but that's because landlords are usually in a better bargaining position, right? Because as a tenant, you need to rent the place, right? And as landlord, you can be picky in your who you want to rent the unit to. And therefore, in such situation, landlord, of course, will instill more obligation on the part of the tenant, right? And this is especially so for commercial lots, right? Where the landlord know that anyone who wants to rent the place is to run a business, and they can afford to pay more rents, and they can afford to agree to more stringent terms. But ultimately, it also also depend on who has a better bargaining power, right? For example, if you're dealing with properties with lower demand, right, where you have more units to be rented out than people who actually want to rent it. So in those situations, of course, the landlord do not have much bargaining power. They cannot even demand for high rental. But typically in Malaysia, the tenancy agreements are more in favor of landlord, right? Again, this is just the general rule. There are exceptions because there have also been situations where parties are at equal bargaining power, and the agreement is fair. Now, the other thing is, one of the topic which I'm going to also speak on later is the Residential Tenancy Act, which seeks to introduce a template tenancy agreement, right? Which I would further discuss that. So perhaps that is the reason for bargaining power, right? One party may have a better bargaining power to dictate what sort of term they want to be in the tenancy agreement, how short is the duration of the notice. For landlords who are in better bargaining position, they can insist for all these clauses, which may not be fair, right, for tenants, or may not be viable for tenants who cannot afford. So one of the issue that the Residential Tenancy Act seek to introduce or seek to address is perhaps one of these issues, which I will discuss further later as well. Now, I'm going to move on to the next topic, which is what are the common clauses, right, in the tenancy agreement, right? Which I've mentioned. Again, those obligations I've highlighted is only some example of the obligation. It is not all. It is still subject to your tenancy agreement, which is why it's always very important to make sure that your tenancy agreement is well drafted. Now, before I go into some of the areas in which you need to ensure that your tenancy agreement covers, right, let me share some of my true story, right, of some of the cases I've handled on the danger in not having a proper tenancy agreement. Now, previously, I have represented one of the renowned developer in Malaysia, right, in a dispute with NSK, right? NSK being the supermarket, the hypermarket, right? Now, what has happened here is that is a commercial unit, tenancy agreement was drafted, but the tenancy agreement actually stipulates that in the event that the tenant, which is NSK, requires aircon to be turned on after business hour, the tenant has to pay for the aircon charges at the stipulated rate of X amount, right? But the problem is what the tenancy agreement failed to mention in the agreement is what happens if aircon is turned on during business hour, right? So it led to argument, right? Both sides were arguing. For the tenant side, they're saying since the agreement says I only need to pay if I require you to on the aircon after business hour, it is implied that during business hour, I do not need to pay, right? That is what the tenant argued. Whereas the landlord, on the other hand, was arguing that, well, what all the agreement is saying that if you want to own it during business hours, we charge you that particular rate. If it is before or during business hour, you still have to pay. It's just that you pay based on the actual aircon rate that has been imposed by TNB or whoever. So this led to argument. The problem is the agreement is not clear. Then parties then have to put forward documents to show what were the negotiation. Right? At the time the tenancy agreement was drafted, the WhatsApp messages and all this understanding, this all need to unnecessary hassle between the parties. Right? You can imagine, right? And in this particular situation, the aircon charges for some month went even higher than the rental which the landlord is supposed to get. So can you imagine, because of the poor drafting, of course, I wasn't involved in the drafting, but because of the poor drafting of the tenancy agreement, it led to such a big dispute, and it may even lead to a lot of huge losses for the landlord as well. So which is why it's very important to have a tenancy agreement, number one, and number two, to make sure a tenancy agreement is properly drafted, to make sure you cover all this obligation. I know oftentimes a lot of property agent or whoever will have a template, or maybe perhaps you as a landlord, you have rented one unit and you use the template for all your other units. But this may not be a good idea. You must still look at whether this template is even applicable for different units, right? So it's very important to have a properly drafted tenancy agreement. Now, the other, now I'm going to go into some of the important area, right, on what needs to be covered. Number one, of course, the details of your property, right? If you are only renting out part of your property and not the full property, you need to make it clear, right? Sometimes you may even attach the plan to it and mark it, like, for example, okay, you're only renting this part of the unit or this part of the lot or whatever, right? And what is the address of the property, you need to make it clear in your tenancy agreement. Now, second thing that you should also make sure you cover in your tenancy agreement is the use of the permits, the purpose of the rent, right? Is it for commercial? Is it for residential? Is it for a specific purpose, a tire shop, a cafe, you know? And you need to ensure that it's not for illegal purpose, right? For gambling or you know, drinking place without license. So all this need to be stipulated in the tenancy agreement as well. Of course, then what's important is the tenancy period. This is also very important, whether it's for 1 year, 2 years, 3 years, how many months, and then whether there's a option to renew. Why this tenure is also important is because, as I mentioned, if it's more than 3 years, there's a requirement for it to be registered under the National Land Code. If it's lesser, of course, there's no requirement to register. But you also need to know when it's expiring, and if it's the extension, how do you extend, right? What is the renewal options, right? And then more importantly, of course, what is the rental amount, right? And the deposit amount, you know, some deposit, you have different types: security deposit, utility deposit, and sometimes when you're renting commercial lot, you have deposit with the management of the building as well. So this will be very clear: whose obligation is it to pay, how much is it to be paid, and how is the deposit to be refunded, in what situation the deposit can be forfeited. All this need to be stipulated in your agreement. It cannot be kept silent. The moment you keep it silent, then you're leaving room for argument, as I mentioned on the aircon case that I've mentioned, right? And then next is the mode of payment, the due date for all the rental, right? Whether it's by way of bank transfer, check, cash, when it needs to be paid, right? Typically, it's on the 7th day without having to demand. And then, of course, some tenancy also will stipulate the late payment charges, right? The interest. What happens if you fail to pay? What are the interest rate? How do you compute interest, right? Recently, we have also been engaged to advise on late payment interest, where the agreement say that if there's a delay in the payment of rental, there's a late payment interest of 20 ringgit per day, right? Which is quite different from your typical, because typically you would just stipulate a 5% interest, you know, per annum and whatnot. But here, the client of mine actually said that it should be paid. The delayed payment interest is 20 ringgit per day. So then the question is, how do you compute this 20 ringgit per day? For example, if for June, right, the tenant don't pay. So of course, from July onwards, you can charge to 20 ringgit, 20 ringgit, 20 ringgit. But what happens if they also do not pay for July? Does it then mean that you charge 40 ringgit? Because then you have interest of 20 ringgit per day for June and 20 ringgit for July. So does it run 40 ringgit per day? or it is still a fixed rate of 20 ringgit per day, right? Again, it is not clear cut, but if the intention is to ensure that the tenant do not delay in their payment and there's actual penalty, one may argue that it should stack up, right? It should be 40 days because you default in 2 months. 40 ringgit, it should be, because you default in 2 months. And if you default in 3 months, then it should be 60 ringgit. Of course, the tenant will say, no, that's not how it should be. It says that so long as I delay, it's just 20 ringgit, right? We sort of defeat the purpose, because if it's only 20 ringgit, it doesn't matter whether I delay rental for 1 month of rental, 2 months rental, 3 months rental, I only need to pay you 20 ringgit, which may or may not be fair, right? Depending on who you are arguing for. But again, to avoid all this argument, again, you need to make it very clear in your tenancy agreement. How do you compute this late payment interest, right? And then, of course, you also perhaps need to stipulate some of the inventory or some of the fixtures and fittings. Because sometimes when you rent a unit, you may not be renting a bare unit, right? You may rent it with furnitures, with tables, chairs, aircon. You may want to state it in your tenancy agreement. Why? Is because, as I said, the dispute I mentioned earlier, which I've done on the tire shop, it is very important because one of the contention there was that you do not have pictures of what was in the house or what was the state of the house when you rented it to me as a tire shop, right? So then the issue of whether I have restored the unit to the original position became a dispute, right? What is there, what is not there, and which is why it's important for you to list out what is actually in your house, right? And in the event that there's something that's missing or something that's been broken, at least you have some sort of a record that, right, you're supposed to have 4 aircons, but you only get back 3 aircons in return. You have some sort of record and you can have recourse against the tenant in the event that when they return it back to you without those inventory, right? Of course, then you also should have your termination clause, right? How do you terminate? Some tenancy agreement will say it's for a fixed term, right? 3 years. Does it allow for you to terminate early, right? If there is, you need to put it in. How do you exercise the right to terminate? When can you exercise the right to terminate? And typically in the tenancy agreement, you should have the circumstances. You need to make it, set it out very clearly, right? It's very important. Why? Is because if you don't list out the possible grounds in which you can terminate, then it may lead to the argument that you have wrongfully terminated, right? So it is again very important to set out under what situation in which you have the right to terminate the agreement. And then, of course, you have your obligation of landlord and tenant, right? All the obligation to pay charges, buy insurance, and your renewal option. Subletting, as I mentioned, right? If the landlord do not allow subletting, you should put it in your stipulate in your tenancy agreement. You cannot sublet. An escalation clause, right? You may ask me, what is escalation clause? Escalation clause essentially is a clause which allows the landlord to have the option to increase their rental, right? It is not common, but I have seen clauses like this. Typically, you can increase rental during the renewal stage, right? But I've also seen clauses which says that then landlord can at any time increase the rental if the market rate suddenly go up, right? Again, these are all applicable more in situation where there's unequal bargaining power, right? When you're in equal bargaining power, I doubt parties will agree to give any party the right to increase or reduce the rental. Okay, so these are some of the important areas that you must cover in your tenancy agreement. Otherwise, as I said, you will lead to dispute. And in Malaysia, there are a lot of tenancy dispute. And the common one is the refusal to return security deposit, failure to pay rental. Then what are your rights, right? Which I also discussed in part 2, which is the common problem in tenancy. Now, before that, here are some of the regulation or laws in Malaysia which may be applicable for tenant and landlord, right? At the moment in Malaysia, there's no standard tenancy agreement. There is no fixed statute that governs tenancy and law. But all we have is the Contracts Act, Civil Law Act, Extract Act, National Land Code, Specific Relief Act, right? For Contracts Act, of course, it's established a general principle of Contract Act and deals with situation of void contract, illegal contract. For example, if you rent out your unit for illegal purposes, right? Under the Contracts Act, it is deemed void, right? Then you also have the Civil Law Act, right, which allows have specific act section 28 sub 4, if I'm not mistaken, which allows landlord to charge double rental if the tenant refuse to return the vacant possession of the unit. And then you have the Distress Act, right? Distress Act is a forum for the landlord to claim for unpaid rental or apply to seize some of the tenant's property in the unit in order to pay off some unpaid rent. And of course, you have the National Land Code, which governs the land ownership. Like I said, if it's more than 3 years, you need to register. There's a requirement under the National Land Code. And then you have the Specific Relief Act, right? Specific Relief Act is a avenue for the landlord to evict tenants. And of course, then you have case law, right, which provide guide. The court give guide on how to interpret all these sections, all this law. So as you see, as a lawyer myself, and even as landlord and tenant, you see that your right seems to be from different acts, right? It's from Contracts Act, Civil Law Act, Distress Act, National Land Code. So you may wonder, like, when do I use this particular act, or how do I know whether this particular act apply to me or whatever not, right? Of course, to that, number one, that's where your lawyer comes in. They will have to advise you. They'll tell you, okay, your rights under this section, under that section, they will tell you. And secondly, which is why perhaps that the KPKT is looking to pass the Residential Tenancy Act, right, to bring all of them together and to ensure that there is some sort of a transparency and consistency as well, so that you have everything in all the different acts into one act to regulate this tenancy, the relationship between tenant and landlord. So now, moving on to the next part, which is some of the problems, right, that everyone face in tenancy, right? This is important because only when we identify the problem, we can try to find the solution. Then we will then move on to discuss whether the Residential Tenancy Act is the solution for everyone, right? So first of all, of course, is the issue of early termination, right? It's very common in Malaysia. Sometimes you rent a place and then you find, for 3 years or 2 years, and then you find that, hey, I don't quite like this place. Or for example, you find a better location or better rent, right? A better rental rate. So you'll be wondering, hey, can I terminate this agreement, right? Can you do that? And this question has been answered in the case of Berjaya Times Square. One of the issues that arises is if you terminate prematurely, can the landlord sue you for the unexpired term? Meaning you rent for 3 years, you may have rented the place, you only pay the rental for 2 months, then you want to terminate. Can the landlord insist you pay me the rental for the remaining 2 years and 10 months? Right? This was discussed in Berjaya Times Square. What has happened here is that Twin Gems have rented a space from Berjaya Times Square, right, for 3 years tenancy agreement to operate an F&B outlet, right, food and beverage outlet. But 77 days in, right, when they rented the place, Twin Gems wanted to terminate the tenancy, right? And because they're saying that the place that they rented does not seem to be doing well. There's not a lot of customer coming in, and therefore they said, look, this is not viable for me. I want to terminate. So what happened then was Twin Gems returned vacant possession, gave the key, and abandoned the unit. Of course, Berjaya Times Square then say, no, you can't do that. You agreed to rent it for 3 years. You must rent it for 3 years, and therefore Berjaya sued for the unpaid rental for the unexpired term, right? And of course, here the court found in favor of the landlord. And this is what the court has said, right? Pursuant to clause 10, plaintiff, which is Berjaya, were entitled to claim for the unexpired term as liquidated damages, right? So the other question that was also posed to the court in this case of Berjaya Times Square against Twin Gems is whether the landlord can forfeit the deposit, right? And the answer to that is, again, yes, you can forfeit, and it's because the court have looked at clause 10 sub 2 of the tenancy agreement. So again, I'm not going to say that because of this case, you can sue for an expired term and you can forfeit. There is express clauses in the tenancy agreement which allows the plaintiff, which is the landlord, to claim for all this. If your tenancy agreement do not have these clauses or is silent or if unclear on whether you can sue for an expired term, whether you can forfeit the deposit, this is going to lead to issue. Which is why, again, I emphasize it's very important for you to have a properly drafted tenancy agreement. Because in Berjaya, of course, they have clauses which give them this right, right? Now, the second more common problems or common issue that tenant and landlord face is when tenant refuse to pay rental, right? So this is very common. Many of you face it. So you may ask yourself, right, how do I kick the tenant out, right? They're still staying in the unit, don't want to pay me rental, but don't want to leave the unit, right? Some landlord may try to be creative. They might ask, oh, can I cut off the electricity? Right, because sometimes maybe you are the one who's paying the electricity bill as a landlord, and you should see that, well, if they don't pay me rent, I'm not going to pay the electricity bill. Let the TNB cut off the electricity, right? Or maybe landlord may think, okay, I change the lock, right? When the tenant goes out of the house, I change the lock, I don't let them come in, right? Some landlord may think this is my house, I should be able to do it, right? So the question then is, can you do that? The answer is no. Why? Is because the court have made it very clear that you need to get a court order in order to kick out your tenant, because Malaysia protects tenant. So you need to have proper avenue, because otherwise then landlord will just act on their own, right? Maybe they just change the lock and all this, then it will lead to a lot of issues, which is why Malaysian court have made it very clear. If you want to evict any tenant, you must get a court order. And the court, in the case of Dr. Haji Singh and Suhaimi bin Samad, have said it would be wrong, right, on the part of the defendant, which is the landlord, to lock up the plaintiff, the tenant, from the clinic and taking the law into their own hand, right? And it says that the Section 7 of the Specific Relief Act, right, shows that Parliament intended that any eviction must be obtained through a court order. But not to worry. Of course, it may seem that it's a bit troublesome, because sometimes landlord may come to me and say, hey, Chewing, this doesn't seem fair, isn't it? They are staying there, they don't pay me rental, and I have to pay lawyers to get a court order to evict them, and it's very troublesome because it's not an easy process, not a quick process, it's not a cheap process, right? But to balance that, then the court have actually, the Parliament has actually also passed act, right? The Civil Law Act, which allows you as a landlord to claim for double rental. Meaning to say, if you have terminated the agreement and you've asked the tenant to give you the vacant possession and they refuse, they still want to stay there, you can actually claim for double rental. Meaning, for example, if the money rental is 1.4K a month, from the day the tenant refused to give you the vacant possession, you can start charging 2.8K a month, right? So this is some of the initiative or that from Parliament to try to balance the right? Of course, you may come to me and say, well, what's the point, Chewing, if they can't pay 1 month rental, what's the chances that they can claim for double rental, right? Which is then why many a times a lot of landlord want to select the tenant, right? They want to choose the tenant that they think can pay, which is also often subject to complaint, right? The third problem I've listed here is discrimination, right? Oftentimes we always see advertisement, right? They want to rent to female only, right? Rent to a particular race only, right? Of course, this is definitely not a good thing to do, because you are stereotyping, right? You're thinking that a particular individual, a particular race, right, cannot afford to pay you rent, or you know, will not take care of the units. These are discrimination, right, which is against the fundamental human rights, right? But how do you balance that with the right of landlord to make sure that I rent it to someone who can actually afford to pay rent, right? Because from what you see, if the tenant do not pay you rent, it seems like such a big hassle for me to kick the tenant out, right? I cannot just go and change the lock. I cannot just get someone to come and kick them out. I have to go to court. I have to engage a lawyer, to pay lawyer, to get a court order, right? It may seem a bit of a hassle. So of course, as landlord, you will want to the extent possible to filter out, right? Who are you renting the unit to? Make sure that the tenant can pay. But does this amount to discrimination, right? That is also something that is always debatable, right? And then the fourth type of common problems in Malaysia is the refusal or the abuse of the use of deposit, right? So oftentimes you pay 2 months security deposit and 1 month utility deposit to the landlord, right? Landlord will hold on to it. And come the end of the tenancy, of course, ideally the landlord is supposed to return this deposit to the tenant. But this is where the dispute always arises, which is when the landlord say that, hey, I'm not going to return it to you because you have not rectified the unit. You have not restored it, right? Oftentimes it's always an argument, right? Because the problem is, like I said, even the case of the tire, there's no proper record on what is in the premise or what is the state of the premise, right? There's no photos, right? When you return back, the landlord starts saying, hey, no, this wall is supposed to be blue color. And then the tenant say, no, it's always been black color, right? You end up in a dispute, right? Which is why I always go back to why it's important to set out in your tenancy agreement what is the state of the unit when it was being rented out. Which is why something also important. Perhaps you may want to consider enclosing some of the photos in your tenancy agreement so that you avoid this issue, right? Can you imagine, especially for commercial lot, there will be major renovation that has been done up, right? For tire shop, you need to dig holes to go down to service the car from the bottom, or for restaurant, certain partition that will be done, right? There will be major renovation work. So as landlord, if you want it to be restored to how it was, all the more it's important for you to take photos of how the unit is before it's being rented out, right? It's important so that you avoid this dispute, even for tenant, right? And for tenant, it's also good, beneficial for you to have this record so that the landlord cannot use this as an excuse to not pay you the security deposit, right? If you can say that, look at this photo, this is how it is, I have restored it to be this condition, there's no grounds, no reason for the landlord to still withhold your security deposit, right? And then, of course, then the next common problem is the unequal bargaining power, as I mentioned, right? Sometimes the landlord may be in a better bargaining power, or maybe the tenant. And this oftentimes leads to a one-sided contract where there's certain clauses which is more in favor of the party who have the higher bargaining power, right? For example, when the tenant is in urgent need to rent a house, right, then they'll be forced to accept unreasonable terms, right? For example, a very short notice period if you want to raise any issue, or a high payment interest and whatever not, right? So these are some of the common problem. And of course, then the last one, as I mentioned, there's no centralized legislation. Legislation is all over, right? You have the Contracts Act, you have the Civil Law Act. So these are some of the common problems in Malaysia, which then brings me to the part 3, right? Which is the Residential and Tenancy Act, which of course ideally is aimed to address some of the problems that I just discussed, right? Um, and what are some of the areas in which the Residential Tenancy Act is aimed to cover, right? Number one, it intends to be a comprehensive legislation to regulate the residential tenancy, right? To make sure that everything is brought into one. You don't have to look at different area. Just look at this act. You know what is your right as a tenant and landlord. You know what is your obligation as a landlord, as a tenant. And then you also provide a template residential agreement, right? This is will be something similar to your Schedule H and Schedule G. For those who do not know, for housing developer, there is a fixed, a standard template of the sale and purchase agreement, the SPA, that you have to comply with. You have to utilize the standard form in your agreement from the developer and the purchaser when you sell the house. So now with this Residential Tenancy Act, the Parliament is also seeking to introduce a template tenancy agreement. Of course, one would hope that the template tenancy agreement will be fair, and it won't be lopsided, and it will instill certain standard obligation, right? Of course, on the landlord side, the landlord must ensure that the premise is fit for rental, and provide proper notice to the tenant. And of course, on the tenant side, the template agreement will instill certain obligation which is notice to vacate, obtaining consent before subletting, and all this obligation, right? For now, it has not been confirmed. There is also uh, talk of having a minimum amount of notice template agreement. So this is one of the things that this the RTA is seeking to address. And second, which is more big, which is a bigger change than the industrial practice, which is on the dealing of security deposit, right? This is, of course, to address the issue of refusal to return deposit and abuse, which I mentioned earlier. Now, what this act is seeking to impose is, number one, they fix the amount of deposit that you can collect, which is 2 months rental for security deposit, and utility deposit will be fixed at 1 month. This is pretty much standard. I think that those at this rate as well. But the more crucial one is this deposit. Instead of paying to the landlord, which is the industry practice, the act seek to compel the deposit to be paid to a controller, which is the independent party, which is like you're akin to your housing controller for housing development. But here you have a tenancy controller. It will be set up by the act. You pay to this party, and more crucially, the controller then have control of the money, so that, of course, he prevents a situation where the landlord refuses to return the deposit. So if the money, the deposit is being paid to the controller, upon expiry, the controller must return it to the tenant, of course, subject to any set-off, right? For example, if the landlord says that, oh, you cannot return because they damaged my property, I've incurred X amount to repair it, so you must pay me that X amount from the deposit. Any balance, then you return, right? So the controller is in charge. The other important thing that the Act seeks to introduce is the interest, right? The interest that's been generated from the deposit under the Act the interest will be used to fund the tribunal, which I'm going to come to later, which is point 4, as opposed to the industry practice. For now, when the deposit is being paid to the landlord get to keep for the duration of keep the deposit for the duration of the tenancy, and whatever interest that has been generated will be kept by the landlord, typically, right? Typically, when you're holding it to it, if you put it in FD, there's any interest, the landlord will keep, because your tenancy agreement will say that you have to return the security deposit without interest. So these are dues which have actually caused a lot of complaint, of course, particularly from the landlord side, right? Because you no longer have control of the security deposit and you can no longer benefit from the interest. But I guess what the Act is trying to do is to strike a balance, right? To avoid some landlords who unreasonably withhold the refund. And then for landlord side, sometimes the amount is so little that the amount that they have to pay the lawyers to sue the landlord to get back the security deposit may not even be worth it. So what will end up happening is the landlord get to keep the security deposit 3 months of rental for free, right? Which is why this Act is trying to prevent. So, and then of course, the Act also seeks to establish a tribunal, right? A tribunal, which is a forum to resolve dispute, right? It's something akin to your housing tribunal or your interrelationship tribunal to hear employment dispute. So for this Residential Tenancy Act, they are going to also set up a tribunal to deal with tenancy dispute, right? And the idea is, of course, for the dispute to be dealt with in expedition. You don't always have to go to court, because to go to court, it's not going to be cheap, it's not going to be quick, right? So what this Act seeks to introduce is to have a tribunal, which, number one is whoever sits in the tribunal will be familiar with all this dispute, so they can decide on the dispute at a very quick rate, and also on a very cost-effective manner. So this is another thing that the Residential Tenancy Act is seeking to introduce, to have this tribunal. And the Act also will definitely make it clear that any decision by this tribunal will be final, and you can not challenge it on merit. You can only challenge it on, for example, the serious irregularity in the award. Otherwise, the decision will be final. So you don't end up in court where, like, even though you win in the court of first instance, there's appeal, right? That is what this act is trying to prevent. You only stop it at that level, right? And more importantly, is the RTA is also seeking to introduce anti-discrimination clause, right? Previously, I have mentioned one of the problems is a lot of landlord may discriminate against a particular gender or particular age group or particular race. You know, they will select that I only want to rent it to a particular group of tenant, right? So what this act seeks to do is to prevent, right, such discrimination based on race, employment status, or gender orientation. The idea is to promote equal access to housing, right? That is what the Act is trying to promote, right? Of course, there's other aspect of it as well that the Act is trying to introduce. These are only some that I've highlighted. Like I said, this Act is also still at the consultation stages, right? They're getting all stakeholders to give their feedback. Of course, not everything that's been introduced have received positive feedback. There are also some which have received criticism, which is what I'm also going to discuss some, right, limitation and challenges, right? Number one, some of the criticism is that it seems to interfere with the party's right to contract, right? The freedom of contract. Why? Is because number one, you're introducing a template, right? A template which previously parties are free to negotiate the terms. You're free to say no. You're free to go around and shop around and negotiate the terms with me. But with the act, with the introduction of the template agreement, you may argue that then my right to negotiate have all been gone, right? And of course, then number two, from the landlord side, they may think that, oh, you're interfering with my right to choose tenant, right? How do you strike the balance? As a landlord, seeing that there's so much hassle to evict a tenant, of course, you would want to the best ability you can to ensure the tenant is financially strong to pay you the rental, right? So does this amount to a discrimination, right? How would the RTA implement this or word this anti-discrimination clause? All this is yet to be seen, right? How do you draw that balance? And of course, there's also rumors of the RTA seeking to also regulate rental rate, right? To cap the rental rate or to fix the rental rate. This has not been confirmed yet, but if this is truly implemented, one may argue that, hey, you're then limiting my right to charge how much rental I want to charge, right? And of course, the last limitation is for now, it is only applicable to residential properties. It does not apply to commercial, right? If also, for example, it's going to exclude any student hostel, worker accommodation, and also it's going to exclude short-term rental as well, right? For example, Airbnb and whatever not. Of course, for now, it's also not clear whether it apply to SOHO, small office and home office unit. But for now, whatever that I've discussed, the act and all this, whatever seek to be introduced, will only be applicable to residential unit, right? So all in all, in Malaysia, definitely there's a lot of problems with tenancy. But for now, until and unless the Residential Tenancy Act is passed, to conclude, it's still very important to have a properly drafted tenancy agreement to set out what is your right, what is your obligation, when to return security deposit, how interest and all this is very important. Otherwise, then we have to wait and see what's going to happen with the Residential Tenancy Act and to see whether it's going to be in favor of landlord tenants or it's going to strike a balance. Yeah, so that's all I have to share today. Thank you again, once again, Excel, for having me here. In the past, I open the floor for any Q&A.
All right. Thank you, sir. I believe we have some questions for you in the chat box. Let me just scroll through and see, because it's quite random.
Uh,
Let's see. Okay, the first one will be from Miss Nur Zahira. Hi, Mr. Leong. I have a question. If it's a 3-year tenancy with option to renew, can that still be considered a tenancy without needing to register?
Yes, I think you can still be considered as a tenancy. You don't need to register it. But of course, oftentimes we see usually it's 3+3. I don't really see 3+3+3+3+3. Yes, you can still be considered as tenancy.
All right, cool. Next would be one from Nur Bazila. Do security guards have the authority to or right to request, hold, or scan a person's identity card before allowing entry to any of the premises?
Uh, well, that's an interesting question. Of course, security guard, why they sometimes do that is for security purposes, right? They need to record who is entering and not entering into the premise. So, depend on the context, but if you ask me in general rule, they have that right to ask, especially if you're entering into someone else's premise, right? There's a right for even like for those who are not in condominium, even in your house. I'm sure you have a right to demand you show me who you are, right? Before I allow you to enter to my house. So I don't see any issue with that.
All right, thank you, sir. Next would be from Maria Arifin. In the event of default by the tenant, is it allowable for a landlord to cut electricity and water or locking up the premise? And is it possible to state these rights in the tenancy agreement?
Well, as I mentioned, I think the Malaysian court made it very clear. These are what you call a self-help remedy, meaning to say that you are trying to take law into matter into your own hand. The court say you cannot. Even if you expressly state it in the tenancy agreement, it may still be subject to challenge because they'll be saying that you're trying to contract out of what is stated in the act, in the statute. The statute actually say that you cannot. You need to get a court order. So I would think the answer to that is no. Even if you have that right in the tenancy agreement, this is still subject to challenge as well.
Thank you, sir.
Mm.
Here's one from Celine Law. If preterm by tenant, can the landlord forfeit all deposits and claim unexpired term at the same time, or can they only do either one?
Okay. Again, my answer to that, number one, is you need to look back at your agreement, right? Because your agreement will be a Bible. It will say whatever rights you have. But in general rule, of course, the court will have to see which avenue you want. I would say that if your agreement actually say you can do both, there's no harm in you doing both. The only problem is if you want to also claim for costs to restore the unit, right? And if the cost to restore the unit is less than your deposit, that's when you might have an issue because the idea is that the tenant might argue the reason why you're holding to the deposit is to use it to restore the premise in the event the tenant do not do it. So what happened then is if you actually incur an amount that's lesser than the deposit, you forfeited the deposit, can you still claim for the cost to restore? That one is a bit arguable. But as far as deposit and unexpired term, if your agreement says you can do both, you can do both.
Right. Thank you, sir. Here's another one from Maria Arifin. Other than compensation or payment of the unexpired term by the tenant due to early termination, can landlords state for tenant replacement obligation?
Yes, if it's in the agreement, you can do that. But of course, then is a question of how viable is this? Because if the tenant, from the tenant point of view, they will be thinking, if I already need to pay you for the unexpired term, why should I still need to find you another tenant? Right?
Mm,
Again, it all depends on the bargaining power. Of course,
yeah,
if you're in a higher bargaining power, you say, no, I want you to pay the unexpired and I want you to find a replacement for me. Right? If it's an either or, then perhaps you can consider putting it in your agreement. If I don't want to rent it out, I find someone to replace, then I don't have to pay you for the rest. Again, if it's stipulated in your agreement, you can do so.
super. Next one from Farid Milan. If a tenancy agreement has already expired, let's say in December 2024, and a new tenancy agreement is not yet drafted, is it possible to issue a temporary renewal until the latest date, or does the rules and regulations in previous agreement is still applicable during the period?
Okay. Now, this is an interesting question. It's quite common actually in Malaysia where you have 2 years rental, but after 2 years, everyone just kept quiet. Landlords, the tenant still pay, landlord just kept quiet. In Malaysia, what then happened is upon expiry, you'll still be deemed to be in a tenancy at will, right? Tenancy at will means it deems that your tenancy is renewed on a monthly, right? So you can terminate by notice to give notice immediately. So all the previous obligation arguably will no longer be applied. What then happen is you are renewing your tenancy on a monthly basis.
Thank you.
So of course, the best case scenario is to properly have another tenancy agreement to record the entire duration. Otherwise, you're living on a month-to-month basis.
Right. Next would be uh, from MCM Lai Chu. How many months tenant delay payment before we can allow to ask tenant to move out? Any specific minimum period?
The answer is no. For now, there's no law which says you have to have a specific minimum period. Ultimately, again, depend on your clauses in your tenancy agreement. But typically, the standard clause that I've seen is so long as you default even 1 month rental, you have the right to terminate, you have the right to evict. But again, it all depends on your terms of your tenancy agreement.
Mm. All right, sir. Thank you. Next, we have one from Nazri Muhammad. Can landlords or management, GMP, doing the tenancy agreement without lawyer agency? Can
Oh,
yeah,
I think the question meant whether you can draft it yourself.
draft it on your own, yeah. With,
Of course, it's definitely not encouraged. Why is because there's, like I said, there's a lot of obligations that need to be in the tenancy agreement. And if you to do it yourself, number one, it's going to create a law issue. Sometimes, of course, I know from tenant or landlord point of view, you want to save. But I can tell you the amount you save in engaging a lawyers to draft the agreement, you may end up having to pay more when the problems arise on the
Mm,
security deposit and rental and all this. So if you
right.
ask me, of course, it is not encouraged.
Thank you, sir. Next, another one from Maria Arifin. In the event of default by the tenant, is it allowable for landlord to cut electricity and water on locking up the premise? Oh, sorry, I think you've answered this.
Yeah.
Okay. Uh, thank you. Next, one from Satish Munyandi. It's actually a two-part question, I believe. Or like 5 parts. Let me just. Okay, first one. Who should bear the outgoings in general? Indah water, cukai tanah, and cukai taksiran. That's the first one.
Yeah. For cukai tanah and cukai taksiran, typically again you must look back at your agreement because it may be otherwise. Typically the landlord will have to pay. But in the water, I'm not too sure because in the water falls within utility. It also falls within electricity, water bill, and all this. Sometimes agreement may say the tenant have to pay because sometimes it depends on the usage. So again, go back to your agreement.
All right, so the second part is if we allow perpetual renewal or auto renewal, 3 + 3 + 3 is a mandatory to honor it. Is it mandatory to honor that?
Okay. Of if it's in the agreement, of course you have to. But of course, then the issue is how do you exercise the +3, the +3? Do you comply with it? If you don't comply, of course, then the other side might argue that there's no obligation for me to renew. In fact, I think there's a Malaysian case, or old case, which is similar like this. There's an agreement to rent it perpetually. So the court was saying if it's actually clear enough that there's such obligation, the court will honor it.
Hmm. Next would be what is a reasonable penalty charge? Penalty charges for uh
Not amounting to
not
exorbitant.
amounting to exorbitant rate. Yeah.
Again, typically in Malaysia, I think an interest rate of 5% is considered reasonable, but again, it's subject to agreement. So it all depends. There's no fixed amount. So I would
Hmm.
think 5% per annum.
Next one is stamping, a mandatory requirement. What about internal company to company tenancy? Do we need to stamp?
The answer is yes, tenancy agreement need to be stamped because if it's not stamped, it cannot be tendered in court. And there's certain penalty as well for not stamping the agreement.
if the tenancy agreement is expired, and they continue to stay as periodical tenancy, can the landlord forfeit the security deposit?
No, because if you are continuing staying on, there's no right for you to forfeit the security deposit. Any forfeiture must be pursuant to the agreement. And strictly speaking, once the tenancy have expired, landlord's supposed to return the security deposit to you. And then the tenancy is then renewed on a monthly basis. So again, subject to your agreement, but from what I see, the landlord cannot forfeit the deposit.
All right, thank you, sir. That was all the questions by Mr. Satish Munyandi. And next, we have another one from Mr. Farid Milan, and I think this will be the last one for today. Both parties somehow did not get the agreement stamped, and suddenly issues arise. Does the agreement, can it be brought to court?
Answer is yes, you still can tender it in court, but you must first stamp it. If you don't stamp it, of course, the timeline for you to stamp I presume, would have lapsed, but you can still stamp it, just that you need to pay the penalty for stamping it. So as soon as you stamp it, then you can then bring the agreement to court. You can tender the agreement to court.
All right, thank you, Mr. Chi. We've now come to the end of this. Hopefully, first of all, a sincere thanks to you, sir,
No worries.
for delivering such insightful and practical session. We hope today's discussion has sparked new ideas and reflections to all of you participants, and we hope to see all of you in the next one. Thank you, sir.
Thank you. Thanks for having me. Thanks, everyone.
Yeah.